Let me see if that's recording. I think it is. All right, so hi everyone. Welcome to today's meeting of the University of Oxford Southernizing Criminology Discussion Group. It's a pleasure to host Dr. Gail Super today. She'll give a talk titled Casks, Compounds and Containers, Judicial and Extrajudicial Infrastructures of Punishment in the Old and New South Africa. We are absolutely delighted to have Gail joining our group and contributing with what will certainly be a great exposition. So thanks very much, Gail, for accepting our invitation. Before I hand over to you, Carla will briefly introduce you and we'll also kindly remind the audience of some practicalities.
Yes, so Gail Super, as you may know, is an assistant professor at the Department of Sociology at the University of Toronto, also working at the Center of Criminology and Social Legal Studies. Her research program focuses on the political context of penal policymaking, specifically the role of crime and punishment in constitutional political authority and vice versa. She has published in Theoretical Criminology, Law and Society Review, Social and Legal Studies, and the British Journal of Criminology. And her book, Governing Through Crime in South Africa, was published by Ashgate in 2013. Thank you very much, Dr. Super, for being here with us today. In terms of practicalities, we will have first her presentation, which will be accompanied by some slides, at least at some points. And after that, we'll hold a Q&A, which Luis and I will moderate. For that purpose, as you probably know, we ask you kindly, if you can, to turn on your cameras. And of course, you're welcome to do so now. Only be aware that we are recording this session, so it's possible that you will be visible once the presentation is then uploaded. Without further ado, please, Gail, thank you very much, and the floor is yours.
Good morning, good afternoon. Thanks very much for inviting me to present my work here today. In my talk, I examine the role of everyday infrastructures in vigilante violence in former Black townships and informal settlements in South Africa. I argue that car trunks, shacks, containers, and other commonplace receptacles function as the underside of official institutions, such as prisons and police lockups, and that they bear deep historical imprints and institutional legacies of the extrajudicial punishments that were inflicted on Black bodies during colonialism and apartheid. They also serve as important reminders of the uneasy relationship between local meanings and manifestations of justice and liberal legality. I focus on two specific techniques. Firstly, when someone is forced into the trunk of a vehicle and driven around in order to locate stolen property. And secondly, when a person is temporarily detained, assaulted, and/or tortured in a garage, shack, container, or local public space. Since there is no statutory offense of vigilantism in South African law, this form of self-help is framed in the police database as the common law offense of kidnapping, colloquially referred to as man-stealing, and is usually combined with alternative charges of murder, attempted murder, and/or assault with intention to cause grievous bodily harm. Like police torture, it is more of a furtive and private ritual than a public act. As such, it differs from spectacular incidents of collective violence, where a suspected offender is publicly burnt, stoned, or beaten to death by a crowd. While kidnapping as a technology of organized or politically motivated crime is a much studied phenomenon, it has been relatively under-theorized and neglected as a form of vigilantism, both in South Africa and elsewhere. It raises important questions about the overlaps between organized crime and crime as a moralistic form of social control, to use Donald Black's words. I use the term extrajudicial penal violence to refer to punitive violence that is inflicted beyond the courts. From a strictly legalistic perspective, this is not punishment. However, in practice, it is very much like punishment. those on the receiving end, and sometimes the instigators themselves, regard it as punishment. Extrajudicial punishment, like law, is multiscalar and spatio-temporally plural. It assumes different forms, distinct forms, and plays out differently, depending on where in space and time it is inflicted. This multiscalarity is highly visible in historically marginalized spaces and in contexts of inequality. Although kidnapping and the associated violence meted out against suspected criminals seems at first glance to be the opposite of lawfully exercised state power, I argue that it reflects, amplifies, and distorts the violence that is exercised by the state in support of its claimed monopoly over lawful penal power. The extrajudicial civilian-led penal violence that I discuss in the paper exists in close proximity to state practices of policing and punishment. While official punishment relies on the infrastructure of the criminal justice system, prisons, police vehicles, police cells, lockups, handcuffs, etc., those who inflict extrajudicial punishment in marginalized spaces have to tap into infrastructures which are situated in or on the margins of the state. These infrastructures, and specifically the way they are used to inflict extrajudicial punishment, are the products or spatial forms of past and current social relations. In South Africa, the law itself created spatial exclusions and spaces of marginality via legislation such as the Group Areas Act, which not only established, but also compelled most citizens to live in racially segregated townships. Thus, spatial forms of economic and social inequality are particularly marked. I'm going to argue that non-state infrastructures, such as the container, the truck, the minibus, and the car, and the trunk, are liminal or shadow spaces which are temporarily converted to achieve a punitive purpose by non-state actors in marginalized spaces. The vigilante kidnappings and extrajudicial spaces of confinement both mimic and distort the practices, forms, and technologies of the state's penal and police power. This brings to mind the concepts of subversive mimesis and subversive affirmation. The former term is developed by Feldman in his book, Formations of Violence, and the latter is used by critical art theorists Arns and Sasser. Imitation, in other words, mimesis, is subversive when it appropriates and subverts the original, using what Arns and Sasser refer to as over-identification to reveal the obscenity of the original. In this case, the expulsive violence which underpins the state's lawful power to punish and police. In doing so, subversive mimesis also produces more violence. In making the argument that these are the underside or shadow of formal infrastructures of punishment, I do not claim an equivalency. I'm not arguing that there is a direct or linear connection between the prison and the trunk of a car or a shack in an informal settlement, but rather that there is a similarity between the nature of the power itself and the use of violence against those who threaten or violate societal norms. Okay, so I'm going to attempt to do a screen share now. The primary research for this paper consisted of an analysis of computerized data from 6 police stations for the years 2000 to 2016 in the Khayelitsha and Inyanga policing clusters in the Western Cape. These stations have among the highest rates of recorded violent crimes in the country. They are also notorious for incidents of lethal vigilante violence. I conducted an initial automated search of the vast Excel spreadsheet database for the crimes of arson, assault GBH, attempted murder, malicious damage to property, kidnapping, public violence, and murder. to find cases that were potentially vigilante related, using the search terms that you can see on the slide. I then read through the comments columns of the cases which the initial search had flagged to determine whether the cases were connected to the punishment, prevention, or investigation of crime. The comments column contains police descriptions of the alleged crime, whether there was an arrest, whether there was a criminal charge, a court case, etc. By selecting data from these violent archives, I risk sensationalizing what are in essence tragic fragments of people's lives. However, there is also violence in not knowing and in not exposing what many in South African society and beyond turn a blind eye to. I'm going to briefly discuss legal pluralism and extrajudicial penal violence in a historical context before discussing contemporary kidnappings and confinements. The type of state that European colonizers imposed onto African colonies was different to that in the metropole. Tactics of penal violence, such as corporal punishment and criminalization, combined with processes of expulsion and dispossession to produce spaces of marginalization. In this context, infrastructures such as compounds, mines, townships, and hostels were either carceral in design to facilitate surveillance and control, and/or they permitted a plethora of actors to punish lawfully in support of or justified by the pursuit of summary justice. This was further enabled by poorly trained administrative officials who exercised judicial, legislative, and executive powers against Black subjects, mostly via regulation and hence beyond the reach of judicial oversight. As Channock notes, this pluralist legal approach explicitly sanctioned violence and patriarchal power relations and subjected Black Africans to an extensive, localized, and legally arbitrary form of rule, to use Channock's words. The courts generally accepted the evidence of white experts who embraced an authoritarian view of customary law. Thus, local chiefs and headmen could impose unreviewable orders and fines over their subjects, along with imprisonment for non-compliance. Traditional heads of rural households could also lawfully inflict reasonable corporal punishment for the purposes of discipline. Closed compounds, mining hostels, and Black townships were designed to maximize surveillance and control, to keep Black and white labor separate and ensure a steady supply of cheap Black labor. Within these spaces and elsewhere, there was a thrust towards summary justice for so-called natives, with penal violence being an essential part of this justice. Apart from the power of summary arrest over anyone who defied his authority, native commissioners, who were invariably male, were given delegated powers of punishment, which were not subject to judicial review. Mining compounds had stokkies, small wooden huts, where miners could be locked up for a few days and punished for minor offenses. It was standard for Black workers to be detained without pay after their contracts ended, to ensure that they had not stolen any diamonds. White farmers also used to lock up their laborers at night. These forms of detention were illegal, but largely accepted. The use of violence to control wage laborers by boss boys on farms and indunas, chiefs on mines, was common. Like mining compounds, Black townships were designed to enable maximum control with minimum effort. They were situated as far as possible from white neighborhoods, but close to the industrial areas. And there were a minimum number of access roads into and out of the township. As Mills notes, their geometrically formal, internally identical street pattern was confusing to navigate for outsiders, and because it was legible from above, also provided a way to concentrate together and control a large amount of people. So I'm going to show a slide to demonstrate this. So here you can see this diagram is of the 1953 layout for the Witbank native township. You can see the national road on the one side, and on the other side, there's a river which forms a natural boundary. And then internally, you can see this identical geometrical layout. And this is an aerial photograph of Alexandra Township in Johannesburg. Once the National Party gained power in 1948, it poured enormous resources into continuing the forcible relocation of Black people to the urban periphery and to Bantustan's homelands in impoverished rural areas. The apartheid state was more concerned with protecting white citizens from the supposed criminal threat presented by Black people than it was with the prevention of crime inside Black townships. Hence, there were very few police stations in Black townships. Township residents were forced to rely on interpersonal and patronage networks as forms of security, and vigilante associations were common. There were 2,000 enforced disappearances under apartheid, most of them perpetrated by members of the police security branch and counterinsurgency unit during the 1980s, when the National Party government resorted to increasingly violent and underhand tactics to fight against die swart and rooi gevaar, the black and red danger. The case of Simelane that Jeremy Sarkin talks about in his work, a young anti-apartheid activist who was last seen in the trunk of a policeman's car in 1983, tortured and detained at a block of flats, and thereafter at a farm in the northern part of the country, is one example of how cars, boots, flats, and farms were deployed as infrastructures in the disappearances and extrajudicial punishments secretly carried out by the state in the name of security. This infliction of horrific and deeply punitive violence by apartheid state operatives shaped counter-violence by the comrades against Impimpi's apartheid spies, the police, the hated community councillors, and other apartheid collaborators inside Black townships. Petrol bombing, arson, stoning, and necklacing were far more common than abductions and torture, although some counter-violence did include these technologies. Thus, the state's excessive violence created forms of resistance that distorted, mimicked, and exaggerated the state's original violence. This engendered further spirals of violence, precipitating new forms of violence as well. During the 1980s campaign of ungovernability, the line between political and ordinary crime became increasingly blurrier, and popular justice initiatives against collaborators and apartheid spies sometimes collapse into violent punishments for ordinary criminal offenses, such as theft and the use of drugs. Beatings were inflicted by some people's courts, and liberation movements in exile also relied heavily on flogging as a disciplinary technique, with harsh punishments meted out against deviants in the camps, including tying offenders to trees and locking them in windowless containers, sometimes for smoking cannabis. By the time the first democratic elections were held in 1994, there was a deep historical legacy of instant justice in which violence played a crucial role. Extrajudicial civilian-led penal violence is now largely deployed against the generic as opposed to the political criminal. While appearing to be gratuitous, it is subversively mimetic in as much as it confirms the logic of state punishment, rendering its violence explicit, while also challenging its claim to monopolize it. The post-1994 South African state has embraced community policing alongside punitive and exclusionary discourses and practices of crime control. In both rich and poor areas, it is the unemployed young Black man who is accused of criminality and hence vulnerable to violence by both the police and others. affluent people living in formerly whites-only areas enjoy the benefits of resources and infrastructures such as private security, electrified fences, gated communities, insurance policies, vehicles, more police stations, and social capital, which facilitates access to the criminal justice system. In marginalized spaces, however, everyday infrastructures and objects are adapted to serve multiple purposes, including that of punishment. Thus, a piece of wire can be transformed into a handcuff, a boot into the back of a police vehicle, a beach into a death or torture chamber. In one case, someone was accused of stealing his neighbor's property and forcibly taken to a community hall, which was temporarily transformed into a people's court. After female participants were ordered to leave the room, it morphed into a violent interrogation center in which the accused was suffocated with a plastic bag, strangled and beaten with a plastic sjambok whip. Despite the severity of the assault, the police comments record no serious injuries. In another case, a young man was abducted and assaulted so badly that he had to spend a week in hospital with an intercostal drain in his chest. He was beaten with a firearm, wood, and hammer, forced into the boot of a small car and driven around to find stolen property. He took his abductors to a container, which doubled up as a shop for selling stolen goods. But since it was closed, his assailants forced his head under a tap and continued to beat him. Thereafter, they wrapped him in a blanket, put him back in the trunk, and drove him to another container where they intended to incarcerate him for the night. The plan was thwarted when the police arrived on the scene and heard him screaming. 2 years later, after a process of court-ordered mediation, the charges against his assailants were withdrawn on the condition that they apologized and paid him 1,500 Rand, which is approximately $100 US. $100 for a week in hospital, a broken leg, stitches in his head, back, neck, and a collapsed lung. It is worth pausing to consider whether this would have happened had the person not been a young Black male from a marginalized former Black township. So I'm just going to show you a slide so you can see what a container looks like. So this is a photograph of a spaza shop, which is an informal shop operating from a container in a former Black township. People purchase items from the window, from a person who stands at the window behind an iron grill. Cars, which are ordinarily conceptualized as vectors of mobility, also serve as spaces of confinement and punishment. Given an overall lack of insurance cover in former Black townships and informal settlements, recovering stolen property is central to residents' sense of justice. And having access to a vehicle renders this more feasible. However, since car ownership is still relatively low in these marginalized, high-risk areas, to use insurance company terminology, the owners or drivers of minibus taxis, colloquially known as quantums or tatas, meaning fathers, play a key role in providing these services, which are generally not free. In the context of a police force which lacks sufficient vehicles with which to investigate crimes, it is unsurprising that the ubiquitous quantum minibuses sometimes function as quasi-police vehicles, tracking down stolen goods and collecting evidence. This explains why the term quantum came up repeatedly in the police database, although I also found less organized instances of sedan-style vehicles, a red Golf, a black BMW, a white Toyota Corolla, a blue Polo, etc., which were temporarily transformed into vectors of violence. In these marginalized spaces, vehicles function as crucial infrastructures of mobility, spaces of confinement, discipline, and specters of death, particularly when someone is taken away and never seen again. The sequence of events plays out along these lines. A car with approximately 6 men stops in front of a home. They ask about the whereabouts of stolen property or of a person, and they leave with someone in the trunk. Being cramped inside the windowless space of a boot has disciplinary, retributive, and instrumental effects. While the vehicle itself is a vector for traveling from point A to point B, the effect of being confined inside a trunk not only disciplines the captive into confessing, but also raises the very real possibility of death. As such, it functions as a space in which a human being is changed into an other, against whom a formidable right to punish is established, to use Foucault's words. Thus, when a quantum arrives unsummoned outside someone's house in the dead of night, it is indeed like a spectre, something ominous and foreboding. Seeing a vehicle full of people is a harbinger of the transformation through violence to come. In one case, 10 men drove off with a 23-year-old who lived in a shack in his father's backyard at 10 p.m. He was never seen again. Sometimes victims are tied to the tow bar and dragged behind a car. One complainant was woken up at 2 o'clock in the morning by a group of taxi drivers searching for his brother, who had allegedly broken into people's houses. They dragged him to a white Toyota Quantum, where he was beaten with a firearm and wheel spanner on his head and body, causing him to lose consciousness. They then bound his legs together with a rope, tied the one end to a tow bar, and drove off. Sometimes the extractive nature of the violence is blatantly obvious, as in the case where 5 men kicked down the door of a shack, forced 2 brothers into their Quantum, drove them to the taxi rank, and punched, shambocked, and stabbed them with a screwdriver because the brothers had allegedly stolen their car tires. They ended up paying their abductors 4,000 Rand, which is about $275, even though they denied stealing the tires. In another case, after a stolen DVD and amplifier were found in a shack, the vigilantes proceeded to take everything that they wanted. They took far more than the value of the stolen goods. Sometimes people are driven to Monwabizi Beach, which was reserved for Blacks only during Apartheid. It borders on the western side of Khayelitsha and is on a stunning but dangerous stretch of the Atlantic Ocean, or the Atlantic coastline. When people are forcibly taken there at night, it is temporarily transformed from a space of leisure into a space of violence and death. In one case, a 23-year-old was abducted while he was at work. He was driven to a graveyard and thereafter to the beach, where he was tortured for a prolonged period in retaliation for having robbed a cell phone and wristwatch from someone in an informal settlement a few days earlier. During the 5-hour assault, he was struck with bricks, stabbed with sharp objects, burnt with molten plastic, forced to drink seawater and eat sand, taken back to the graveyard and left for dead. In another case, 2 brothers accused of stealing their neighbor's laptop were brutally assaulted with shamboks, forced into a car, and driven around to locate the computer, even though they denied the accusations. Their abductors threatened to throw them into the sea, which, due to strong currents and because many residents in former Black townships cannot swim, is akin to a death sentence. While the common garden shed might serve as a space to keep tools and gardening equipment in the leafy middle-class suburbs, in poor former Black townships and informal settlements, those who cannot access formal bricks and mortar houses live in corrugated iron shacks, ihoki, and in garden sheds, colloquially known as Wendy houses, or in Xhosa, iochochombe. They also double up as spaces of incarceration for the purpose of punishment and torture. In one instance, a police officer found 2 people inside a locked shed in someone's backyard. One of them was semi-conscious, unable to walk or speak, with multiple wounds. The other had been beaten and burnt with molten plastic all over his body, because the owner of the house suspected they were thieves and had presumably been torturing them in order to get information. One photograph in a police docket showed a garage which had been temporarily converted into a torture chamber. The police had made markings on the photograph around the bloodstains on a wooden chair in the center and at hooks on the wall. Here, mechanical instruments such as chains and winches doubled up as instruments of torture and confinement. These processes both mirror and distort the central role that arrest and interrogation play in the construction of state power, and they mimic the state's search and seizure practices. Sometimes the state's spaces and infrastructures of accusation coalesce with the spatio-temporal multi-purpose penal infrastructures that I've spoken about here. For example, where a charge of shoplifting was withdrawn after the accused had been arrested and appeared in court, the victim of the shoplifting offered him a lift home, but instead drove him to another house. Here he was interrogated about the whereabouts of the stolen items, burnt with a hot iron and beaten by 4 men, before being forced into the trunk of the vehicle and driven to point out the belongings. They were never found. In another case, where someone was accused of stealing 800 Rand, about $55, from his cousin's wallet, the accuser called her boyfriend, who upon arrival assaulted the suspect, drove him somewhere else where he continued the assault, and thereafter dropped him off at the police station. Despite being a victim of vigilantism, he, in other words, the theft suspect, was handcuffed and arrested by the police. The police do not always cooperate, however, as I discovered when I interviewed a member of an informal community crime prevention group in 2014, who related how he had, together with others, arrested 24 people one night and locked them in some toilets before calling the police, who arrived some 4 hours later at 3 o'clock in the morning. As he bitterly remarked, the police accuse us and tell us it's illegal. They brought them back after 5 minutes, in the same amount of time as it took me to open a Coke. The police van never stopped and told us why they were releasing them. It is viscerally obvious when focusing upon the material infrastructures which non-state actors draw on to exercise penal power, that extrajudicial policing and including torture and punishment are prone to collapse into each other. Yet in South Africa and elsewhere, communities are encouraged to take responsibility for their own policing, and citizens' arrests are lawful. Thus, for example, after community patrollers arrested 2 people who were attempting to break into a house, they detained them in a green container. They then drove them to a taxi rank where they handcuffed one victim's hands together and beat him with a sjambok on his naked body. In another case, where someone had initially gone to the police to report that his cell phone had been stolen, he thereafter, at the investigating officer's recommendation, approached an anti-crime committee for assistance in retrieving his phone. The committee members forced a suspect into the boot of a vehicle and took him to a container that served as their officers. Because he didn't want to tell the truth, he was kept there and violently interrogated by members of the committee for what was one person in the court case described as a long time. He eventually led his interrogators to someone who had a phone that was the same color as the one that had been stolen and identified it as the theft victim's phone. Thus, while forcible confinements in a shack or container does not have the same authority of the law and is not a prison or police lockup in the legal sense of the word, it fulfills a similar, albeit exaggerated function to that of lawful incarceration. The boundaries between torturing just enough to gain information and violent extrajudicial punishment are so porous as to render the distinction between them inane. There are, of course, numerous examples of the police and other state agents engaging in exactly the same practices. I'm just going to make some concluding remarks and to sum up my main arguments. Colonial and apartheid rule encouraged a plethora of actors to punish extrajudicially. whether through the technologies of torture, corporal punishment, and/or judicial and extrajudicial killings, Black lives were deemed infinitely expendable, and state-sanctioned forms of non-state violence or non-state punishments were central techniques of rule. This resulted in deeply rooted and multi-scalar violent extrajudicial punishments, which have shaped current repertoires of violence and violent forms of extrajudicial punishment. These are not the opposite of, but instead they constitute the underside and always present twin of liberal penality. Thus, contrary to liberal discourse on state punishment, extrajudicial punishment is not a post-conviction event, but an ongoing process in which torture and unofficial confinement are central elements. It starts well before conviction, if there is a conviction at all. The expulsive spatial practices, which were historically legislated for in law, resulted in a deeply spatialized form of legal pluralism. This spatialization plays out today in the ways that everyday infrastructures are used to fulfill multiple functions, including penal ones. Thus, spatiotemporality is crucial to both how penal forms permeate space and time, and to how space and time constitute penal forms. As such, the field of punishment and society should broaden the concept of punishment to incorporate what occurs in practice, as opposed to restricting it to what should happen in terms of the narrow confines of liberal theory. The latter completely fails to acknowledge, in fact, it obscures the multiscalarity of liberal penal forms. The vigilante kidnappings and forcible confinements that I've spoken about are not mere instances of gratuitous violence. Instead, they mimic, distort, and amplify the violence that underpins the state's unrealized monopoly over the violence inherent in its own claims to police and punish. At the same time, however, it is not always possible to tease apart the reasons and motivations behind lawful and unlawful punitive violence. The same or similar technologies and infrastructures are deployed for multiple, sometimes conflicting or overlapping purposes. This finding has implications for the mainstream ahistorical and reductionist claim that an inefficient criminal justice system produces vigilantism, which is quite popular in South Africa, this claim, this argument. The term vigilantism itself is an umbrella for a host of violent forms, many of which are deeply rooted in historic practices of state violence. The forms of violence enabled and produced by colonial and apartheid states didn't just disappear, particularly since the new South African state has embraced a punitive approach to crime, which was unevenly implemented. This unevenness was both a product of and a contributor towards spatial inequality. Although the generic criminal has now replaced the terrorist and the impimpi, penal violence targeted at poor, racialized people continues. As such, it is important to study the infrastructures of extrajudicial punishment, precisely because these are not mere objects, but sites of meaning making. Thanks very much. I'd welcome your questions.